Welcome to Knowledge is Power, a video series where we take a scholarly look at the First Amendment. In this video, we'll be looking at the Free Exercise Clause within the First Amendment, which considers how U.S. citizens can practice freedom of religion. If you recall, last week we discussed the Establishment Clause. This week, we are diving deeper into the religious protections afforded within the U.S. Constitution. Hi, I'm Jenny, and I went to law school so you don't have to. My favorite classes in law school were constitutional law classes. In this series, we're taking an in-depth look at the First Amendment of the U.S. Constitution and considering what it protects and what it doesn't. The First Amendment reads, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people to peacefully assemble, and to petition the government for a redress of grievances." The First Amendment's freedom of religion protections are separated into two different clauses: the Establishment Clause, which we looked at last week, once again, and the Free Exercise Clause, which we are taking a closer look at today. But first, the disclaimers. This video does not constitute legal advice. It simply doesn't. Number two, it will not help you pass your Con Law 1 exam. Number three, in this video, we will not be discussing religion or religious theory. The Free Exercise Clause merely states that Congress shall make no law prohibiting the free exercise thereof. That's it. A very simple statement, but there is so much more to it than that. In fact, this is the clause within the freedom of religion that receives the most attention. So many cases. The freedom of religion within the First Amendment reads, "Congress shall make no law respecting an establishment of religion," which we covered last week, "or prohibiting the free exercise thereof." And that's the part we are focusing on this week. So, what is the Free Exercise Clause, and when does it apply? How has it been applied through case law over the years? The Supreme Court has repeatedly found that government may not compel or punish religious beliefs. People should be free to think and believe whatever they want. For example, in Reynolds versus the United States, the 1878 case that is considered the first free exercise case, the Supreme Court considered whether polygamy should be legally protected as a religious belief in the Mormon tradition, despite the Mormons' claim that it was required within their religion. Congress was deprived of all legislative power over mere opinion, but was left free to reach actions. And in Bromfield versus Brown in 1961, the court found that the freedom to hold religious beliefs and opinions is absolute. Thanks, Chief Justice Warren, for that statement. You messed up a lot of other ones, but you got that one right, I think. The Free Exercise Clause, however, does not provide absolute protection for religiously motivated conduct. Instead, the court has determined that two different concepts under free exercise: the freedom to believe and the freedom to act. The first is absolute, but in the nature of things, the second cannot be. That comes from Cantwell versus Connecticut in 1940. The court has also spoken of the distinction between the absolute constitutional protection against government regulation of religious beliefs on the one hand, and the qualified protection against the regulation of religiously motivated conduct on the other hand. That comes to us from Employment Division versus Smith, which we will get into later in this video. So free exercise is invoked in several situations. One, when the government prohibits behavior that a person's religion requires, as we discussed in Reynolds versus United States. Polygamy was forbidden by law, despite the Mormons claiming it was required by their religion. Number two, when government requires conduct that a person's religion prohibits. We see this in United States versus Lee, where the court rejected a challenge by a group of Amish people who claimed that the requirement for them to obtain a social security number and pay taxes violated their religious beliefs. Number three, when individuals claim that laws burden their religious observances or make them more difficult to observe. For example, government is reaching too far into religion if it denies benefits to individuals who quit their jobs for religious reasons. We see this in a few cases that we'll get to here in a bit. As we've seen in previous videos, the Constitution appeals to Congress in its wording, yet it is Supreme Court case law that determines how that First Amendment is interpreted and applied. Throughout the years, the Supreme Court has stated that the government may not require or punish religious beliefs. Let's take a look at some of the cases that have shaped the court's interpretation of the Free Exercise Clause. Now, last week with the Establishment Clause, establishment has been applied mostly to schools, whereas the Free Exercise Clause is a lot broader. It covers a lot more territory, and personally, I find it to be a lot more interesting. That's just me. I'm sure there are some Establishment Clause nerds out there. I'm a free exercise nerd. Let's start off with Employment Division, Department of Human Resources of Oregon versus Smith, which is commonly referred to as Employment Division versus Smith. This case came about in 1990. Employment Division versus Smith considered whether religious peyote use was religiously protected in the state of Oregon, despite its use being generally prohibited in the state at the time. In this case, Oregon was denying unemployment benefits to someone who had taken peyote for religious reasons. Scalia wrote the opinion, and if you want my opinion about Scalia, go back to last week's video on the Establishment Clause. The notes in the margins of my law books are pretty salacious. Because the ingestion of peyote was prohibited by Oregon, and that law prohibiting peyote use was unconstitutional, Oregon was permitted to deny the unemployment benefits when when Smith was fired for using peyote. Up until Employment Division versus Smith, the case law around free exercise was a lot different, as we saw in Reynolds versus United States, the Mormon polygamy case. Reynolds is a case where the court drew a distinction between beliefs and action, and noted that free exercise clause limited governmental regulation of the former, but not the latter. Their initial explicit protection of free exercise occurred in a series of cases that include laws restricting religious groups from fundraising. For example, in 1940, Cantwell versus Connecticut overturned the convictions of several Jehovah's Witnesses who were convicted of soliciting money without a license. The court found that requiring a license to fundraise for religious organizations violated both the Free Exercise Clause and the Free Speech Clauses within the First Amendment. Then, in 1963, we see the landmark decision in Sherbert versus Verner, which set forth a new test and rule for application of the Free Exercise Clause. This is the case that established strict scrutiny as a test for free exercise. So, Sherbert versus Verner centers around a member of the Seventh-day Adventist Church who was fired from her job in South Carolina because she refused to work on her Sabbath day, which was Saturday. Saturdays were the Sabbath within her faith. They were required. They're not optional. And as such, she was unable to find another job in South Carolina that did not require her to work on Saturdays. The Employment Security Commission found that her restriction on her availability disqualified her from receiving unemployment benefits because the benefits insured workers who fail without good cause to accept suitable work when offered by the employment office or the employer. Strict scrutiny is a court's way of saying, government, if you're going to interfere with someone's religious practice, you better have an exceptionally good reason and handle it as gently as possible. So the Sherbert strict scrutiny test has two main parts. Does the law or policy put a substantial burden on religious exercise? Does it force someone to choose between their faith and a government benefit, like Sherbert losing their unemployment, or between their faith and obeying the law? If yes, the burden is substantial. And if so, can the government justify that burden? The government must show that it is pursuing a compelling interest, something really important, like national security or public safety or preventing serious harm. And then the second prong of that is the government has to prove that it is using the least restrictive means, meaning there is no less intrusive way to achieve that goal without trampling on religion. The strict scrutiny test from Sherbert was used for several years, from 63 until 1993, to consider other cases, especially those involving government benefits. In Thomas versus Review Board, a man quit his job because his employer had transferred him to a section of the factory that required him to participate in producing armaments. He felt that was in conflict with his religion and religious beliefs, and ended up quitting, even though many other people that held the same religious beliefs continued to do their jobs producing arms. But he quit his job and explicitly stated that it was for religious purposes. The government was not able to deny his unemployment because he definitely had quit for religious reasons. Hobby versus Unemployment Appeals Commission of Florida was nearly identical to Sherbert. It found that the state was required to give unemployment benefits to a woman who refused to work on her Saturday Sabbath, much like in Sherbert. Frazee versus Illinois Department of Income Security found that requiring unemployed workers to be available 7 days a week infringed upon free exercise and applied the Sherbert test. Further, the court found that it did not matter whether the individual in question was a member of an organized church, sect, or denomination. And that, I think, makes that case stand out a little bit and adds a little interest to it. Now, if you'll recall last week, we discussed that the Establishment Clause primarily applies to, or is primarily applied to schools. But the Free Exercise Clause is also reached into schools as well, and parental rights. So the Sherbert test was also applied to cases involving compulsory schooling. In Wisconsin versus Yoder, the court found that Amish children aged 14 and 15 were exempt from compulsory schooling under Wisconsin law. Wisconsin versus Yoder not only found that requiring children to attend public school at certain ages that disagreed with the tenets of a particular religion, but the case also infringed upon parental rights to control their children's upbringing. Sherbert versus Verner's strict scrutiny test was widely applied from the time the court issued its opinion all the way up until 1993, when Congress passed the Religious Freedom Restoration Act, commonly known as RFRA, or RFRA for short. RFRA's purpose is to restore the compelling interest test as set forth in Sherbert versus Verner and Wisconsin versus Yoder, and to guarantee its application in all cases where free exercise is substantially burdened, and to provide a claim or defense to persons whose religious exercise is substantially burdened by the government. RFRA was adopted to negate the test set forth in Employment Division versus Smith and required strict scrutiny for the free exercise claims, as per Sherbert versus Verner. Going further into case law, let's take a look at Church of the Lukumi Babalu I versus City of Hialeah. This is one of my favorite cases. I find it fascinating, and I don't know, it's had a big effect on, I remember this case so vividly from law school. It's one of the most vivid cinematic free exercise clause cases in modern Supreme Court history. It's got religion, it's got fear, it's got politics and chickens. Lots and lots of chickens. So, in the late 1980s, a small religious group, the Church of the Lukumi Babalu I hope I'm saying that correctly, set up shop in Hialeah, Florida. They practiced Santeria. They actually did practice Santeria, unlike Sublime. Santeria is an Afro-Cuban faith blending Yoruba spirituality and Catholicism. A central ritual involves animal sacrifice, offering chickens, goats, or doves to the orishas, or deities, and then typically eating the animals afterward. When word got out that the Santeria Church planned to open, along with a school, museum, and cultural center, the city of Hialeah panicked. Local officials passed a series of ordinances banning animal sacrifice, supposedly to protect public health and morals. But here's the problem. The city didn't ban all killing of animals, just religious killing. Hunters, fishermen, restaurants, and slaughterhouses were all fine to exist as they were. So the church sued, claiming the ordinances that the city of Hialeah clutching their pearls, had passed, those ordinances violated the church's free exercise clause of the First Amendment. The key question before the Supreme Court was, did the city's ordinances neutrally and generally apply, or were they targeting a specific religion? This was the first major free exercise case after Employment Division versus Smith, all the way back in 1990. The court pored over the city's records and found officials had explicitly discussed stopping Santeria practices. The laws were written so narrowly that they effectively only applied to religious sacrifice, and the exemptions for hunting, restaurants, kosher slaughter, etc., showed that the city's goal wasn't really animal welfare, it was religious suppression. That meant the laws targeted religion, a direct violation of the Free Exercise Clause. Strict scrutiny applied, and the city failed spectacularly. So, Justice Kennedy's opinion gives us one of the clearest articulations of the modern free exercise standard. The Free Exercise Clause protects religious observers against unequal treatment and against laws that are designed to suppress religious beliefs or practices. When a law targets religion, even subtly, the government must prove a compelling interest and that it used the least restrictive means. Hialeah couldn't do that. Result, the church won. In Lukumi, the court looked past polite municipal language and said, you can't outlaw faith just because it makes your neighbors uncomfortable. The First Amendment does not let the majority declare which gods are welcome in within city limits. So, in 1933, Congress passed the Religious Freedom Restoration Act, or RFRA, as we've discussed. It restored strict scrutiny for any federal law that substantially burdens free exercise. The government must prove a compelling interest and the least restrictive means possible. The goal is to make government justify every serious intrusion upon faith. Let's next get into the city of Bern versus Flores, a case that came about in 1997. A small Catholic parish wanted to expand its 1920s mission-style church to fit its growing congregation, but Bern's Historic Preservation Board had denied the permit, saying the old church was a protected district. The Archbishop sued under the Religious Freedom Restoration Act of 1993, arguing that the city's refusal substantially burdened the free exercise of religion. What looked like a zoning squabble turned into a constitutional showdown over the limits of Congress's power and the reach of religious liberty. Now, the court was not thrilled with RFRA, and we'll get back to that here in a little bit. But in order to understand Bern, you have to rewind to Employment Division versus Smith. In Smith, Justice Scalia wrote that neutral, generally applicable laws, like Oregon's drug laws, banning peyote, do not violate the Free Exercise Clause, even if they incidentally burden religion. That decision alarmed both liberals and conservatives, so Congress responded by passing RFRA in 1993, trying to restore the old Sherbert versus Verner strict scrutiny test. RFRA required any government action that substantially burdened religion to be justified by a compelling interest and achieved through the least restrictive means. So when Bern City Council blocked the church's expansion, the Archbishop said, RFRA protects us. Bern said, RFRA is unconstitutional. Congress overstepped its bounds. So, who was right? Congress overstepped its Section 5 enforcement power by trying to redefine what the Free Exercise Clause protects, rather than merely enforcing existing rights. Section 5 allows Congress to enforce the 14th Amendment, not to change its meaning. And that's technically outside of the scope of this series, but RFRA's sweeping reach, applying to every state and local law, wasn't congruent and proportional to any pattern of religious discrimination by states. In Kennedy's words, Congress does not enforce a constitutional right by changing what the right is. Thus, RFRA cannot apply to states and local governments, only to the federal government. So, in doing so, the court created a new standard for Congress's enforcement power, the congruence and proportionality test. Legislation under Section 5 of the 14th Amendment must be congruent and proportional to actual constitutional violations by the states. This test has since shaped voting rights, civil rights, and disability law too, not just religion. And all of those are outside the scope of this video series. Now, ultimately, RFRA survived, but only at the federal level. Congress can still apply RFRA to federal laws and actions, such as we'll see in Gonzalez versus Ocentro, Burwell versus Hobby Lobby, and more, but not to state or local laws. So the state stepped in. Dozens of states passed their own state RFRAs to replicate these protections. This reshaped the balance of power. Byrne reaffirmed judicial supremacy in defining constitutional rights. That is, the Supreme Court, not Congress, decides what the Free Exercise Clause means. This had a ripple effect. The congruence and proportionality test became a key doctrine in cases about the Americans with Disabilities Act, Violence Against Women Act, and more. So, in City of Byrne versus Flores, the Supreme Court told Congress, you can't rewrite the Constitution, even in the name of religion. RFRA might have been born of faith, but Byrne was born of federalism. So, while Smith weakened free exercise protections, Byrne locked that weakness in place, at least against the states. It's one of those cases where the court drew a bright line between moral ambition and constitutional authority. The quick takeaway: RFRA states that the government must have a really, really good reason. It's the modern day lever for believers, individuals, institutions, and even corporations to push back on federal regulations that burden faith. Let's get into Gonzalez versus Ocentro. This is a case that happened in 2006. A small Brazilian origin church in New Mexico. So this small Brazilian church used a sacred tea called ayahuasca in its religious ceremonies. The tea contains DMT, a hallucinogen banned under the Federal Controlled Substances Act. When U.S. Customs officials seized a shipment of it, the church said, hold on, this isn't drug trafficking, this is worship. And the federal government replied, bet, no exceptions. It's illegal under federal law and international treaty. So the church didn't base its claim directly on the free exercise clause within the First Amendment. Because remember, Employment Division versus Smith had made those claims hard to win. Instead, they used RFRA. Under RFRA, the government must actually prove that banning this religious use serves a compelling interest, and it just can't wave around that drugs are bad as a blanket justification. The government argued that uniform application of drug laws was compelling, and the international treaties require prohibition. But the court said, well, you already allow exceptions for some religious use of controlled substances, like Native American peyote. So you can't just say, no exceptions ever. Show us why this exception would harm your interests. The government couldn't. Therefore, the church won. This case is less about drugs and more about how strict scrutiny is. The court demanded real evidence, not just slogans. It didn't let the government claim that its interests were compelling just because the law said so. As Roberts put it, RFRA requires a case-by-case balancing. The government must justify each burden on religion, not rely on general assertions. So the takeaway: Ocentro is a love letter to individualized justice in religious liberty. It tells us the Free Exercise Clause, via RFRA, still has teeth. Compelling interest means prove it, don't just proclaim it. And religious freedom applies to even small, unfamiliar faiths, not just mainstream religions. Next up, we're taking a look at Burwell versus Hobby Lobby stores, which was a 2014 case that considered whether employer-provided insurance should be required to provide birth control to employees. Our story starts with the Affordable Care Act, Obamacare, the ACA. Specifically, the contraceptive mandate, which required employers to provide insurance coverage for certain birth control methods. Hobby Lobby family, devout Christians who own a large, closely held craft store chain, said, "We don't object to contraception in general, but some of these methods prevent implantation of a fertilized egg, which we believe ends human life. We can't, in good conscience, pay for that." If they refused, they'd face massive federal fines, millions of dollars per year. So they sued, claiming that forcing them to choose between their faith and compliance violated RFRA. The case was not brought directly under the First Amendment's free exercise clause. Remember, after Employment Division versus Smith, that road is steep. Instead, Hobby Lobby invoked RFRA. So the key questions before the court were, can a for-profit corporation exercise religion under RFRA? Does the contraceptive mandate substantially burden that exercise? And if so, is the mandate justified by a compelling interest using the least restrictive means? The court said that, yes, closely held corporations can have religious rights under RFRA. Why? Because they're made up of human beings who don't surrender their beliefs when they organize their business. Yes, the mandate did impose a substantial burden. The owners either had to violate their beliefs or pay crushing fines. So then, the court applied strict scrutiny, the same standard from Sherbert and Ocentro. Was this a compelling interest? Or was there compelling interest? Sure, said the court. Promoting women's health is important. Did the government use the least restrictive means? Nope. The government already had a less restrictive option, letting insurers or the government itself cover those contraceptives directly rather than forcing the employers to do it. The result? Hobby Lobby won the case. So, what was the broader meeting? From a free exercise perspective, Hobby Lobby did three major things. It expanded RFRA's reach for nonprofit to for-profit corporations. It reaffirmed strict scrutiny as a robust, real test, not just symbolic. And three, it shifted the balance of religious liberty toward protecting conscience claims, even in the commercial realm. In short, it transformed RFRA from a niche protection for small religious groups like Ocentro into a major tool for businesses asserting faith-based objections to federal regulations. The takeaway? Under Hobby Lobby, religious liberty isn't just for churches or individuals. It extends to business owners who run their companies in accordance with their faith. But it also ignited a modern tension. When does promoting conscience start to burden the rights of others? So if Sherbert was about an individual Sabbath and Ocentro was about a sacramental tea, Hobby Lobby is about faith in the boardroom, the point where personal belief meets corporate structure and federal power. Next up, let's talk about the Little Sisters of the Poor Saints Peter and Paul Home versus Pennsylvania, a case that came about in 2020. Enter the Little Sisters of the Poor, a Catholic order devoted to caring for the elderly poor. They believed that providing contraception coverage, even indirectly, violates their faith. Now, remember the Affordable Care Act's contraception mandate? After Hobby Lobby, which we just discussed, the government created an accommodation. Religious nonprofits could simply sign a form and their insurance provider would provide contraception instead. But the Little Sisters said, even signing the form makes us complicit. We can't be the trigger that sets the coverage in motion. They sued. So the question before the court became, Did the Trump administration have the authority to expand those religious exemptions under the ACA and RFRA? Or did it go beyond what the law allowed? Why, yes, in fact, agencies do have that authority. Under the ACA, the government had broad discretion to decide how to implement preventive care requirements, including who could be exempted. The agencies also had to consider RFRA, which requires the government to avoid substantially burdening religious exercise unless it passes strict scrutiny. So the court said, if RFRA demands consideration of religious liberty, it's perfectly lawful for the agencies to create exemptions in response. In other words, not only can the government make room for conscience, it must think about doing so. Result, the Little Sisters won. From a free exercise and RFRA standpoint, Little Sisters marks a significant moment. It cemented RFRA's influence on federal policymaking. It expanded deference to executive agencies when they accommodate religion. And it deepened the court's willingness to let religious claimants, even institutional ones, define complicity in their own terms. In plain English, the court didn't just say that the nuns were right, it said the government was right to protect their right to be right. That's a little confusing now, isn't it? Little Sisters of the Poor is less about contraception and more about the soul of administrative law. There are even more current cases before the Supreme Court demonstrating that free exercise is a very important part of the Constitution. Let's go ahead and look at some of them. First up, we have Mahmoud versus Taylor. I hope I'm pronouncing that correct. I believe this case was decided earlier this year. What had happened was, in Montgomery County, Maryland, the Public School Board approved certain storybooks for use in its English curriculum that included LGBTQ+ characters and themes. At first, parents could opt their kids out of lessons involving those books, but then the board changed the policy. No more opt-outs and no notice to parents when storybooks with those themes would be used. Parents from several religious faiths, Muslim, Catholic, Eastern Orthodox, etc., objected, saying that forcing their children to participate in instruction with messages contrary to beliefs without having the option to opt out burdened their religious exercise. The key question at the center of this case is, does a public school burden parents' free exercise rights when it requires their children to participate in curriculum that conflicts with the parents' religious convictions without notice or opportunity to opt out? Now, is the board's policy neutrally and generally applicable? If yes, under Employment Division versus Smith, such laws, even if burdensome, may withstand challenge. That is, only under a rational basis review. If the law or policy is not neutral or generally applicable, then strict scrutiny, that is, compelling interest plus least restrictive means, may be required. Also, if the religious burden is of a kind that substantially interferes with religious development, as is with Yoder, or imposes coercion, stricter review may apply. The court held, for now, in favor of the parents. Public schools must allow opt-outs when curriculum imposes a substantial interference with religious beliefs. In particular, the combination of the LGBTQ plus inclusive storybooks plus no opt-outs plus no notice was found to substantially burden the religious development the parents wish to cultivate in their children. Importantly, the court emphasized that this kind of burden is similar in character to what Wisconsin versus Yoder addressed. Even if a law is factually neutral and generally applicable, when it reaches into the religious upbringing of children, especially younger children, and exposes them to ideas that parents believe threaten their faith, that interference can trigger more rigorous constitutional protection. I don't necessarily think that the court got this one right, but that's just my opinion, man. Now here's where it gets juicy. The ruling suggests that schools cannot just silently include material that parents believe undermines their religion and refuse to give an escape valve, an opt-out, or at least a heads up. The procedural component, known as an opt-out, matters constitutionally, even if a policy is neutral and generally applicable. If it imposes a burden on religious development in children of the kind that Yoder and related cases recognized, strict scrutiny may apply. This marks a prudential widening of religious liberty protection in education. Public education is a public benefit that cannot be considered on surrender of religious freedom. The court recognized that parents don't lose their free exercise rights when they use public schools. The policies of access or forced exposure without opt-outs or notification cannot implicitly require parents to abandon their beliefs as a condition of public schooling. Administrative burden arguments get limited here. The school board, among its justifications, said that opt-outs were unmanageable, cause absenteeism, disruption, etc. The court did not accept that administrative convenience can always overrule the religious freedom when the burden is significant. Mahmoud versus Taylor is likely to be remembered as the case that said, you can't force kids to sit through lessons that violate the parental's faith without giving parents a warning or a way out. It stretches the free exercise clause into the everyday class discussions, into storybooks that might feel harmless to some, but deeply offensive to others. It underscores that religious freedom isn't just about worship. It's about what children are taught, when, how, and whether parents have a say. In this video, we discussed the history of the Free Exercise Clause of the First Amendment and the Supreme Court's lengthy interpretation of the Free Exercise Clause. We also looked at what the requirements were in order to bring a case under free exercise, and we considered many ways in which the government has infringed upon the free exercise of its citizens. We looked at the compelling interest and strict scrutiny requirements set forth in Sherbert versus Verner, and we looked at how RFRA changed the free exercise landscape in 1993, and how it has been applied since it was adopted. If you're still here, thanks. I know this was long. If you've made it this far, congratulations. And if you like this video, please remember to like and subscribe. Leave me a comment below letting me know your thoughts on the Free Exercise Clause and whether the current court is getting it right or not. Or whether you have any questions. Leave them in the comments below. I'm happy to answer those if I can. Next week, we'll be taking a look at freedom of speech, and that one is certain to be a doozy. Be sure to subscribe to be notified when we post that video. And watch last week's video where we broke down the Establishment Clause within the First Amendment. I will try and link that somewhere below. In the meantime, take care of yourself. We're in unprecedented times, and boy, do I wish we lived in precedented times. Head on over to our shop and treat yourself to something nice. Until next week, I'm Jen. Thanks for joining me. Free Palestine, and remember, we still have not seen the full Epstein files yet.